And the section that gives Congress the power to set up a patent system gives the reason why several of the things in the patent system are the way that they are. The main purpose is to promote the progress of science and the useful arts. And the way they do that is they've got a carrot, right? The carrot is they give you this onerous, hideous thing in American law, which is a commercial monopoly. And in exchange for that, you have to teach the rest of the world what your invention is. And there's various rules to get you to disclose your invention more quickly so that the progress of development can accrete or add on to your invention and build up a competitive system. So we've got all of the patent laws are spelled out in United States Code, and there are the various rules in the federal regulations, and then the Patent Office has its own procedural rules for how they actually carry out examinations and the filing of applications and things like that. So as I mentioned, here's the deal. To promote the progress, you have to teach the world. And to do that, and this gets to the question that Siva put on the board, is you have to provide an enabling description with drawings. And the standard is you have to enable somebody of ordinary skill in that art you have to teach them how to make and use your invention. So you can't hold back information that would otherwise enable the invention in its best mode. It has to be functional. And then you have to define what you're claiming as the scope of your property right in the section of the patent called the claims, which are individual paragraphs using very awkward language to describe in hopefully a definite way what it is that you have a monopoly on once your patent issues. So that's what you receive as a monopoly. It's a temporary monopoly. It used to be 17 years from when your patent issued, and that led to all kinds of problems. Some people gamed the system to tremendous financial benefit for themselves and problems for everybody else. So they changed the rule, and now it's 20 years from when you file your patent application. What that does is it encourages people to prosecute efficiently and quickly through the patent office so that they get the full 20 years of protection. And the thing about a patent application, when a patent attorney or an agent or an individual sits down and writes their own patent application, specifically the claims, you're writing a national market regulation. These things basically take on the weight of law that applies to everybody else. And so the language that's used in it is pretty important. Changing a comma here or there, or the use of one word that sounds similar to another but has a very different meaning can affect your rights in a substantial way. So what does a patent let you do with your invention? The other question that Siva asked. It doesn't really let you do anything with your invention. It's a negative right. It allows you to prevent other people from making, using, selling, offering for sale, or importing your invention into the United States. So it gives you that right, but unfortunately it doesn't convey to you the ability to do that. Because patent litigation is expensive, you have to have the ability to know when somebody is copying your thing, your invention, and generally access to the ability to prevent people is expensive. You're talking attorneys, you're talking sometimes legal experts, you're talking the court systems and all the rules and regulations in proceeding through those. So it's difficult sometimes to actually defend the patent that you get, and that becomes a very important key consideration when you're deciding whether you should apply for a patent, and the reasons why, and the financial investment you want to make in those patents. So I wanted to put patents up among the other types of IP protection that either might be better in certain circumstances or that you might also want to pursue in addition to patents. So the advantages of a patent is that it's pretty robust. There's a lot of protection built up around it. There are multiple types. There are plant patents, design patents, utility patents to cover different things. And ignorance is no defense to patent infringement. So people can innocently infringe your patent. They're still liable. There's also intentional infringement. Those people are potentially triple liable for damages. The disadvantages are that the patent process is expensive, both to obtain the patent and, as I mentioned, to defend it. Your patent teaches your competitors what you're doing. So as soon as you file it, from your filing date, 18 months out, it remains secret, confidential at the patent office. But then the patent office now publishes those. And the rest of the world at that point can see what you're doing. They see that you're an applicant. They may see that your company owns the patent. And they see that you or your company have decided to make an investment in this technology. So your competitors are put on notice. And right away, because it describes everything, they can use that to develop additional technologies beyond that. They might actually get a patent that's one step beyond yours, and you continue leapfrogging each other like this over time. Patents expire. They only last 20 years from filing date, so it's not a really long-term protection. You'd have to maintain them by paying maintenance fees, 3 of them throughout the term of the patent. Otherwise, it will expire. And defending them is very expensive. Trade secrets and trademark are both very similar. They come from the same laws. They're also robust, and they're potentially eternal if you keep maintaining them. But trade secret, I'm sorry. I was thinking trademark and trade dress. Trade secret is different. Trade secret, there are state laws on trade secret. Okay, and trade secrets are robust. They're potentially eternal. Think of the recipe for Coca-Cola. It's been around for 150 or more years because they keep it in a vault somewhere. Only a limited number of people know it. They can't fly together on planes, et cetera, et cetera. If you don't know what's in it and you can't test it and find out, that's pretty robust protection. But the instant it leaks out, the protection all goes away. And if you don't take reasonable steps to protect it, it can go away. So trade secrets have limited applications. They apply best to things that people can't see, and exposure kills the protection. It's trademark and trade dress that come from the same law. These can expire if you don't maintain them, and you have to police them so that your marks don't become generic. Think escalator, aspirin. Things like this used to be trademarks. They became generic, and all the trademark protection was lost. And then copyright. Copyright's a little unique in that copyright protection springs into being as soon as you set pen to paper and start writing, or as soon as you create an artwork or something like that. It has a fairly low threshold for creativity and originality. And copyrights are permanent, but they're long-term. They're much longer term than patents. So if you think of Walt Disney, created Mickey Mouse back in, what, the 20s or something like that, it's still protected. In fact, they went to Congress, and Congress extended the statute, added some additional time onto it, so that Mickey Mouse wouldn't fall into the public domain. Here, I think it was like 2003, or maybe it was in the 90s. And there are different rules for different types of copyright, so copyright law gets a little bit convoluted. But this is a whole suite of protections, and patents has its place in there. Patent basics. Okay, it protects the novel, non-obvious, useful machines. These are your 3 thresholds for patentability. Machines, processes, manufacturers, compositions of matter, improvements. So compositions of matter, they'd be like chemical compounds and things like this. Manufacturers would be things you'd make using those. As I mentioned, federal law applies. There are 3 types of patents. The one that most people are familiar with is utility patents. This would be like, a patent to the swivel chair. Design patents, you think about things like a Nike shoe that has some kind of unique design to it. It only protects the appearance of something. So you make changes to the appearance, you may step outside of the patent. And you can get a patent, you can get both a design patent and a utility patent for the same type of thing, but one of them protects just the appearance, the other one protects structure, function, things like that. And then plant patents, I'm guessing probably none of you will be involved in this. This is very specialized, but it's unique genetic hybrids and things that people may create, modifications, genetic modifications. The fungus-resistant wheat or something like that. There are provisional patents, patent applications, and non-provisional patent applications. A provisional doesn't have any claims. It's never examined by the patent office, and it never becomes a patent itself. It dies, it expires after a year. What it does is it gives you the chance to disclose to the patent office, and here's what my idea is. Here's the date I invented that. Now, Up to 1 year from there, you can file a regular application and claim priority, and your effective filing date is that earlier filing date. So it lets you get something in and establish your time rights. But if you don't then file a follow-up, claiming priority, it dies, and somebody else that comes along in between your filing date of the original one and your later filing date can beat you for priority, and they get the patent. So provisionals have a place, especially with the new law coming up. They can become especially important. Non-provisionals are the actual patents that have claims and are examined by the patent office, and those are what become patents. The U.S. is unique for, at least for the next, 9 months or so. We are a first to invent. We're unique in the world that way. Most countries are a race to the patent office. It's first to file. And we'll become a modified first to file in March of next year. So that, I think, one of the other panels will be talking about. Patent term extends from the filing date. I mentioned that. The protection is defined by the claim. So this is getting to the question earlier. Everything that's described and drawn in your patent application, that's not everything that is protected by the patent. Only what is recited in the claims. So you might describe this much and claim this much, and this is all the protection you get. And if you don't file another application to some of the rest of that, it all becomes dedicated to the public. So it's something to keep in mind when you're reviewing a patent application that somebody prepares for you, to make sure that the claims encompass everything you want to protect. No infringement is impossible. Is possible without a patent. When you file an application, you are not able to charge people with infringement and prevent them from doing whatever your patent application describes or even claims. You don't have the right to exclude people until you actually get a patent, because that's when the patent office has determined what you actually have a right to a patent for. Patents often get, or applications often get narrowed, claims get narrowed during prosecution. And then lastly, as I mentioned, you can be an innocent infringer and you still infringe. You can't patent things that are abstract ideas, mathematical formulas, some business methods, generally things that could be conducted only or could be performed by your head or written on paper, not patentable, because you can't, a patent doesn't give anyone a right to prevent other people from thinking in a particular way. Natural phenomenon, gravity, things of this nature, or naturally occurring living organisms. Big debate with people, and they talk about cloning and things. Already publicly known information. This is generally called prior art. If it's been patented, published, or is publicly known before you invented your invention, then your invention is not patentable. And your actions or somebody else's actions can prevent you from getting a patent. This is what you have to be really careful about. If you or somebody else sells your item, offers it for sale, uses it publicly in the United States, or publishes or patents it anywhere in the world more than 1 year before you file your application, you're dead for a patent. You can't get one. And there are other requirements, there are other things that can prevent you as well that are a little bit less common. So what is prior art? It's any information that individually or when combined with other information that's out there indicates that your claimed invention is not patentable. Prior art may teach only one feature in your claimed invention, but if it's combined with something else that teaches the other features, then it does what's called making your invention obvious, and you don't satisfy the threshold of patentability. Generally, this includes anything accessible to the public before the filing of your application. So it could be a graduate student's thesis that's in a library at a university, so long as it's searchable by an index in the library. It could be anything on the internet. It could be prior patents or filed applications that have been published. It could be it could be actual products that somebody has taken to market. So anything out there that is in the public awareness. Questions whether to patent or not. So advantages of patenting: protects your investment, or at least takes steps towards protecting it. Prevents competitors from copying your product if they're honorable competitors. Some people go for ego patents. It's a small minority and generally not business people. Makes your company more attractive to investors. A patent is property. It has both inherent value and perceived value. And it makes your product more attractive to customers because it says, this is new, right? And new is a huge advertising slogan. For not patenting, why not? Well, it's very expensive. If you're fund limited or getting a patent isn't justified by the funds it's going to take, you wouldn't want to do it. So it takes a long time. And remember that difference between the red line and the blue line in the graph? That difference is why you're going to be asking your attorney, why is it taking 3 years for the patent office to pick up my patent application and even start examining it? Because they've got a huge backlog at the patent office. As we mentioned, your patent shows competitors what you're doing. So it tips your hand as far as strategy. It gives your competitors a technology boost. If they were behind you, now you've just accelerated them by teaching them. Of course, it's 18 months out from when you invented it. And it gives them the ability, in some cases, to design around you. Because if your claims recite this and that's your protection, I'm just going to change this feature and that feature, and now I'm outside your claims, but I'm basically competing in the same market space. Another IP regime might be more appropriate. Copyright, trademark, trade secret, something like that. So you wouldn't want to patent. Or you recognize that your concept's not patentable, so don't sink the money into it. You might have an agreement with somebody who prohibits you from filing a patent application. And so that's something to be aware of when you're signing agreements with people. Or you don't own the idea. Agreements can get you into that. Or if you have contractors working for you and you don't have an agreement with your contractor stating that you will own anything that they invent while they're working for you. So ownership is a tricky issue. The ownership rights in patents, unlike some other things, they originate with the inventors. And so you either have to have an agreement that they are under an obligation and a duty to assign the patent to you, or it has to be in the type of work environment where, well, as an attorney, I'm going to advise you to always have those agreements in place, even with employees. If you're a co-inventor on it, you will have rights in it, but you will have equal rights with all your other inventors. So you still need to secure their rights into your company or to yourself in order to control the rights of the patent overall. If you don't do that, each and every one of the inventors can license it to whoever they want for whatever amount they want. They can sell their rights to a competitor or somebody else if they want to. You get a lot of out-of-control situations that can impair your ability to compete. So we mentioned the types of patent applications. Just some quick features. Utility is generally directed to the structure of something, the way its parts and how they're arranged, or to a process, which is 2 or more steps or operations. The term is 20 years. A design patent, the term is only 14 years. You don't have to pay maintenance fees throughout its lifetime. They're cheaper to file. They're issued more quickly. They're generally issued at a higher success rate. So oftentimes a design patent can get you both inherent value for financing. It can get you some protection against competitors, and it can do it more quickly than a utility patent. And sometimes you can't get a utility patent for something, a pencil, but if it's a unique design, you can get a patent for the design of it. So it can touch on things that aren't even patentable in another realm. And then plant patents are 20 years, and it protects the propagating material and the harvested material of plants. So think seeds. Talked about the provisionals and the non-provisionals. I think we covered everything except the non-provisional has to include at least one claim. If it doesn't have a claim, it's not a patent, not a non-provisional patent. But it can have as many claims as you want. You pay extra for excess claims over 20, but their claim, I've seen patents with hundreds of claims. So you can attack your invention and protect it from lots of different angles using different claims. A non-provisional patent can become one patent, or it can become multiple patents. If the patent office says, hey, your claims actually recite 2 different patents, we want you to select one of those, or 2 different inventions. We want you to select one of those inventions to continue in this application, and then cancel the claims to the other one, or withdraw it. And you might go ahead and then file what's called a divisional patent, and both of or patent application, and both of those applications become patents. Or you can file a patent, and you have claims to a portion of what you described, and before it's issued as a patent, you file a continuation application to some other part of what you described. And you can continue on with these patent families ad infinitum. I mean, I've seen one patent originally filed that tens of patents have issued off of them over time. And you can add new features in and file what's called a continuation in part application to, as you develop your product and add new features onto it. A non-provisional patent doesn't expire like a provisional patent, but it may be abandoned by you failing to respond to a patent office action or not paying fees or not correcting a defect when you're notified by it. I'm going to do it for my way over time. I apologize. Life cycle of a patent, there's pre-filing. This is your invention and your reduction to patent. Reduction to practice, where you take the concept and you actually turn it into a working design. This is important to document all actions, discoveries, prototypes, and disclosures during this stage so you can prove earlier invention. You want to make sure, as I mentioned, you identify the inventors and either predetermine or otherwise establish ownership by obtaining their rights. Pendency of the patent is after you file it all the way until it issues as a patent. So you need, during that entire time, you need to disclose any known prior art to the patent office. That's a continuing obligation of every inventor and the attorneys that are working on the application for you. And you have to timely argue against any rejections by narrowing the claims or indicating that the rejections are without a factual or legal basis. And then file continuing applications before the patent issues. There's the active term of the patent. So that's everything from the time the patent issues until it expires. So you pay 3 escalating patent maintenance fees during that time, and you police your patent rights against the unauthorized use by others. And things will take place in both of these, which would be things like licensing your idea to others so that you can get a revenue stream or enable you to produce it and sell it, things like that. And then expiration. This is when your exclusive rights terminate. Okay, you can still make and use whatever your invention is, but now so can everybody else. There's foreign patenting. I'm going to blaze through this because it's going to take too long. Foreign patenting, there's 2 ways to go about that. One, both of them allow you to extend the 1-year grace period that's eligible in the United States to other countries where right now they don't have a 1-year grace period except by these processes. Canada is the one exception. The Paris Treaty allows you to file directly in a foreign country and claim priority to an earlier U.S. application. You file within 1 year of the filing date of the U.S. application. The Patent Cooperation Treaty allows you to file a single international application. That application never becomes a patent. But what it does is within 30 months in some countries and 31 months in other countries, you can enter into the national phase in multiple countries or multiple regions. Europe is one region. It does one examination of an application, and once it's found patentable, then you can go into any of the multiple countries in Europe. And this allows you to defer the investment of patent examination in all those countries out to those 30 or 31-month marks, or 42 months in Canada. And the patents will be effective country by country. So if you file an application in a PCT application, then you go into Europe with it, and then it's granted, and you select England and France to get patents in. You're going to have an England patent that is defended and prosecuted in England. You're going to have one in France that's effective in France. And you don't have protection in Germany. You don't have protection in Italy. And you wouldn't defend or apply your France patent to any other country. It only applies within that country. And then your earliest filing date, as claimed, the priority claimed in your PCT application, that's effective against anybody else that comes along later in time in any of the member PCT countries that you later file a patent, get a patent granted in. PCT process, there's 2 phases. The international phase, you file your international application. They review it, they look for prior art, they issue a report saying, here's the prior art that we think is effective against it, or maybe there isn't. And then if you want, you can amend the claims or file arguments, and they'll re-examine it based on the claim amendments and arguments, and see if they still think it's patentable, or if they still think the prior art is effective. After that, you go to the national phase. The countries will pick up the report that the international phase did, and they'll generally start from there and do their own examinations. You have to generally get translations in some countries, China, Japan, well, multiple countries that have non-English prosecution. And then you're arguing patentability with lots of different examiners throughout the world, usually through foreign agents. International patenting becomes very expensive. The costs can rapidly escalate. Maybe 10 patents are going to cost you between $75,000 and $100,000 just to file them and getting rolling in various countries. So I'm going to hold this off till later, and if we have time, get to this, and I'll let my co-panelists keep going. Did I take half an hour? Okay.
Well, as Rick said, the U.S. is unique.